Hello dear friends, today we are going to continue chapter 2 and we have to start from part B. Okay, it is the module page number is page 38 and part B says concept of issue and allotment. Financial markets have an important relationship with economic development. A company decides to issue securities for different reasons. The main reason being raising capital to meet its financial requirements, maybe for starting a venture, repaying debts, expansion, and diversification. This actually reflects indulgence of enormous investor wealth for the sublime reason of economic development. This economic dependence of the corporate sector is a compelling rationale for an orderly regulated environment that boosts investor confidence and assures conformity with prescribed norms. It helps in creating conducive ownership base and wide capacities to create an impact on the national economy. When an investor buys securities, he is enabling the company to carry on its business using those funds. In India, a company planning to issue securities shall abide by relevant provisions of A. Securities Contracts Regulation Act 1956, B. Security Contracts Regulation Rules 1957, C. Companies Act 2013, and D. Securities and Exchange Board of India Act 1992 and rules and regulations made thereunder. Overview of issue of securities. Primarily, issues can be classified as public issue, rights or preferential issues, also known as private placements. While public and rights issue involve a detailed procedure, private placements or preferential issues are relatively simpler. Chapter 3 of the Companies Act 2013 deals with prospectus and allotment of securities. The chapter is divided into two parts. Part 1 deals with public offer and Part 2 deals with private placement. Section 23 of the Companies Act 2013 provides that a company, whether public or private, may issue securities. As per Subsection 1 of Section 23, a public company may issue securities A. to public through prospectus, that is public offer, by complying with the provisions of Part 1 of Chapter 3 of the Act, or B. through private placement or complying with the provisions of Part 2 of Chapter 3 of the Act, or C. through a rights issue or a bonus issue in accordance with the provisions of this Act, and in case of a listed company or a company which intends to get its securities listed, also with the provisions of the SEBI Act 1992 and the rules and regulations made thereunder. For a private company, Subsection 2 of Section 23 provides that a private company may issue securities A. by way of rights issue or bonus issue in accordance with the provisions of this Act, or B. through private placement by complying with provisions of Part 2, Chapter 3 of this Act. The section deals with issue of securities, which is a wider term not restricted to equity, preference or debentures. Securities. Securities has been defined under Clause 81 of Section 2 to mean the securities as defined in Clause H of Section 2 of the Securities Contracts Regulation Act 1956. The relevant section lays that securities include, as per Clause H of Section 2 of the Securities Contracts Regulation Act 1956, securities include shares, scrips, stocks, bonds, debentures, debenture stock or other marketable securities of a like nature in or of any incorporated company or other body corporate, derivative, unit or any other instrument issued by any collective investment scheme to the investors in such schemes, security receipt as defined in Clause ZG of Section 2 of the Securitization and Reconstruction of Financial Asset and Enforcement of Security Interest Act 2002, units or any other such instrument issued to the investors under any mutual fund scheme, any certificate or instrument by whatever name called issued to an investor by any issuer being a special purpose distinct entity which possesses any debt or receivable including mortgage debt assigned to such entity and acknowledging beneficial interest of such investor in such debt or receivable including mortgage debt as the case may be. Government securities. Such are the securities as may be declared by the central government to be securities, and rights or interest in securities. Thus, the word securities includes shares and other instruments. A public company may issue any of the aforesaid securities by way of a public offer or rights or bonus issue or private placement. Public offer here includes initial public offer, that is IPO, or further public offer, that is FPO, of securities to the public by a company, or as an offer for sale OFS of securities to the public by an existing shareholder through issue of prospectus. Public offer has been defined for the first time. Explanation to section 23 state that public offer includes initial public offer or further public offer of securities to the public by a company or an offer for sale of securities to the public by an existing shareholder through issue of prospectus. To increase the accountability of companies and enhance protection to small investors, the term private placement has been defined for the first time in the Act. Explanation 1 to section 42 defines private placement as any offer or invitation to subscribe or issue of securities to a select group of persons by a company other than by way of public offer through private placement offer cum application which satisfies the conditions specified in this section. Governing laws. Issue of securities is governed in the following manner. In the case of a public company, which is a listed entity or is desirous of listing its securities on the recognized stock exchange in India, the issue of securities is governed by the Companies Act 2013, Securities Contract Regulation Act 1956, the SEBI Act 1992, and the SEBI ICDR Regulations 2018. In the case of all issues by private companies, the same is governed by the Companies Act and the power of administration is exercised by the central government, the tribunal or the registrar of companies as the case may be. Section 24 of the Act empowers the SEBI to regulate the matters relating to issue and transfer of securities and non-payment of dividend by listed companies or those companies which intend to get their securities listed. The explanation to section 24 provides that all powers relating to all other matters relating to prospectus, return of allotment, redemption of preference shares, and any other matter specifically provided in the Act shall be exercised by the central government, the tribunal, or the registrar of companies as the case may be. Further, the power relating to forward dealing and insider trading has been delegated to SEBI for listed companies or companies which intend to get their securities listed. Prospectus. In general parlance, prospectus refers to an information booklet or offer document on the basis of which an investor invests in the securities of an issuer company. It has been defined under clause 70 of section 2 so as to mean any document prescribed or issued as a prospectus and includes a red herring prospectus referred to in section 32 or shelf prospectus referred to in section 31 or any notice, circular, advertisement or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate. Red herring prospectus. Under explanation to section 32, it has been referred to mean a prospectus which does not include complete particulars of the quantum or price of the securities included therein. Shelf prospectus. under explanation to section 31 has been referred to mean a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of a further prospectus. The definition clarifies that any notice, circular, advertisement, or any other document inviting offers from public for the subscription or purchase of securities shall be included in the definition of prospectus. Matters to be stated in the prospectus. According to subsection 1 of section 26, every prospectus shall state such information and set out such reports on financial information as may be specified by the Securities and Exchange Board in consultation with the central government, provided that until the Securities and Exchange Board specifies the information and reports on financial information under this subsection, the regulations made by the Securities and Exchange Board under the Securities and Exchange Board of India Act 1992 in respect of such financial information or reports on financial information shall apply. Shelf prospectus. Shelf prospectus means a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of a further prospectus. In simple terms, shelf prospectus is a single prospectus for multiple public. Issuer is permitted to offer and sell securities to the public without a separate prospectus for each act of offering for a certain period. Under the Act, any class or classes of companies, as SEBI may provide by regulations in this behalf, may file a shelf prospectus with the registrar. Such prospectus is to be submitted at the stage of the first offer of securities, which shall indicate a period not exceeding 1 year as the period of validity of such prospectus. The validity period shall commence from the date of opening of the first offer of securities under the prospectus, and in respect of a second or subsequent offer of such securities issued during the period of validity of that prospectus, no further prospectus is required. An information memorandum is required to be filed by a company filing a shelf prospectus, which shall contain all material facts relating to new charges created, changes in the financial position of the company as have occurred between the first offer of securities or the previous offer of securities and the succeeding offer of securities, and such other changes as may be prescribed, with the registrar within the prescribed time prior to the issue of a second or subsequent offer of securities under the shelf prospectus. According to Rule 10 of the Company's Prospectus and Allotment of Securities Rule 2014, the information memorandum shall be prepared in Form PAS-2 and filed with the registrar along with the fees as provided in the Company's Registration Offices and Fees Rules 2014 within 1 month prior to the issue of a second or subsequent offer of securities under the shelf prospectus. The section also provides a benefiting provision for the investors. The proviso provides that where a company or any other person has received application for the allotment of securities along with advance payment of subscription before the making of any such change, the company or other person shall intimate the changes to such applicants, and if they express a desire to withdraw their application, the company or other person shall refund all the monies received as subscription within 15 days thereof. Red herring prospectus. Red herring prospectus means a prospectus which does not include complete particulars of the quantum or price of the securities included therein. In simple terms, a red herring prospectus contains most of the information pertaining to the company's operations and prospectus, but does not include key details of the issue such as its price and the number of shares offered. According to Section 32, a company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of a prospectus. Such company proposing to issue a red herring prospectus shall file it with the registrar at least 3 days prior to the opening of the subscription list and the offer. A red herring prospectus shall carry the same obligations as are applicable to prospectus, and any variation between the red herring prospectus and the prospectus shall be highlighted as variations in the prospectus. Upon the closing of the offer of securities under this section, the prospectus stating therein the total capital raised, whether by way of debt or share capital, and the closing price of the securities and any other details as are not included in the red herring prospectus shall be filed with the registrar and the Securities and Exchange Board. According to Clause 1 of Section 2, of the Act, abridged prospectus means a memorandum containing such salient features of a prospectus as may be specified by the Securities and Exchange Board by making regulations in this behalf. Section 33 of the Act provides that no form of application for the purchase of any of the securities of a company shall be issued unless such form is accompanied by an abridged prospectus. A copy of the prospectus shall, on a request being made by any person before the closing of the subscription list and the offer, be furnished to him. Nothing aforesaid shall apply if it is shown that the form of application was issued a. in connection with a bona fide invitation to a person to enter into an underwriting agreement with respect to such securities, or b. in relation to securities which were not offered to the public. The penal provisions provide that a company which makes any default in complying with the provisions shall be liable to a penalty of 50,000 rupees for each default. Offer for sale deemed prospectus. Public offer includes or an offer for sale OFS of securities to the public by an existing shareholder through issue of a prospectus. Under Section 25 of the Act, where a company allots or agrees to allot any securities of the company with a view to all or any of those securities being offered for sale to the public, any document by which the offer for sale to the public is made shall, for all purposes, be deemed to be a prospectus issued by the company. In simple terms, any document by which the offer or sale of shares or debentures to public is made shall for all purposes be treated as prospectus. The document offer for sale is an invitation to the general public to purchase the shares of a company through an intermediary such as issuing house or a merchant bank. A company may allot or agree to allot any shares or debentures to an issue house without there being any intention on the part of the company to make shares or debentures available directly to the public through issue of prospectus. The issue house in turn makes an offer for sale to the public. All enactments and rules of law as to the contents of prospectus and as to liability in respect of misstatements in and omissions from prospectus or otherwise relating to prospectus shall apply to such offer for sale. Following additional information to the matters required to be stated in a prospectus. A. The net amount of the consideration received or to be received by a company in respect of the securities to which the offer relates, and B. The time and place at which the contract where under the said securities have been or are to be allotted may be inspected. According to the section, in order to construe offer for sale, either of the following conditions needs to be fulfilled. A. Offer for sale to the public was made within 6 months after the allotment or agreement to allot, or B. At the date when the offer was made, the whole consideration to be received by the company in respect of the securities had not been received by it. As for the singing of the prospectus, the section provides that where a person making an offer to which this section relates is a company or a firm, it shall be sufficient if the offer allotment is signed on behalf of the company by 2 directors of the company, and in case of a firm by not less than 1/2 of the partners in the firm, as the case may be. Offer for sale of shares by certain members of a company. Section 28 of the Act permits certain members of a company in consultation with Board of Directors to offer in accordance with the provisions of any law for the time being in force the whole or any part of their holdings of shares to the public. The document by which the offer of sale to the public is made shall, for all purposes, be deemed to be a prospectus issued by the company. All laws and rules made hereunder as to the contents of the prospectus and as to the liability in respect of misstatements in and omissions from prospectus or otherwise relating to prospectus shall apply as if this is a prospectus issued by the company. The section lays that the members, whether individuals or bodies corporate or both, whose shares are proposed to be offered to the public, shall collectively authorize the company, whose shares were offered for sale to the public, to take all actions in respect of offer of sale for and on their behalf, and they shall reimburse the money, all expenses incurred by it on this matter. The rule in this context provide that the provisions of Part 1 of Chapter 3, namely Prospectus and Allotment of Securities, and rules made thereunder shall be applicable to an offer of sale referred to in Section 28 except for the following, namely A. The provisions relating to minimum subscription, B. The provisions for minimum application value, C. The provisions requiring any statements to be made by the Board of Directors in respect of the utilization of money, and D. Any other provisions or information which cannot be compiled or gathered by the offerer with detailed justifications for not being able to comply with such provisions. Further, the rules provide that such offer document or prospectus issued under the section shall disclose the name of the entity bearing the cost of making the offer for sale along with reasons. Issue of securities at a premium. A company may issue securities at a premium when it is able to sell them at a price above par or above nominal value. The Companies Act 2013 does not stipulate any conditions or restrictions regulating the issue of securities by a company at a premium. However, the Companies Act does impose conditions regulating the utilization of the amount of premium collected on securities. Share premium to be transferred to securities premium account. Subsection 1 of Section 52 states that when a company issues shares at a premium, whether for cash or otherwise, a sum equal to the aggregate amount of the premium received on those shares shall be transferred to a securities premium account, and the provisions of this Act relating to reduction of share capital of a company shall, except as provided in this section, apply as if the securities premium account were the paid-up share capital of the company. Utilization of securities premium. In accordance with the provisions of Subsection 2 of Section 52 of the Act, the securities premium can be utilized only for A. Issuing fully paid bonus shares to members, B. Writing off the balance of the preliminary expense of the company, C. Writing off commission paid or discount allowed or the expenses incurred on issue of shares or debentures of the company, D. For providing for the premium payable on redemption of any redeemable preference shares or debentures of the company, or E. For the purchase of its own shares or other securities under Section 68. Subsection 3 of Section 52 further states that the securities premium account may, notwithstanding anything contained in Subsection 1 and Subsection 2, be applied by such class of companies as may be prescribed and whose financial statements comply with the accounting standards prescribed for such class of companies under Section 133. A. in paying up unissued equity shares of the company to be issued to members of the company as fully paid bonus shares, or B, in writing of the expenses of or the commission paid or discount allowed on any issue of equity shares of the company, or C, for the purchase of its own shares or other securities under Section 68. Firstly, the premium cannot be treated as profit, and as such the amount of premium is not available for distribution as dividend. Secondly, the amount of premium, whether received in cash or in kind, must be kept in a separate account known as the Securities Premium Account. Thirdly, the amount of premium is to be maintained with the same sanctity as the share capital. Where a company issues shares at a premium, even though the consideration may be other than cash, a sum equal to the amount or value of the premium must be transferred to the Securities Premium Account. Head Henry and Company Limited versus Ropna Holding Limited. Any premium paid does not give the shareholder any preferential rights in case of a winding up. Monies in the Securities Premium Account cannot be treated as free reserves as they are in the nature of capital reserve. There is a Departmental Circular number 3/77 dated 15/4/1977 that is given. Prohibition to issue the shares at discount. Section 53 states that except as provided in Section 54, that is issue of sweat equity shares, a company shall not issue shares at a discount. Any shares issued by a company at a discount shall be void. A company may issue shares at a discount to its creditors when its debt is converted into shares in pursuance of any statutory resolution plan or debt restructuring scheme in accordance with any guidelines or directions or regulations specified by the Reserve Bank of India under the Reserve Bank of India Act 1934 or the Banking Regulation Act 1949. Where any company fails to comply with the provisions of this section, such company and every officer who is in default shall be liable to a penalty which may extend to an amount equal to the amount raised through the issue of shares at a discount of 5 lakh rupees, whichever is less, and the company shall also be liable to refund all monies received with interest at the rate of 12% per annum from the date of issue of such shares to the persons to whom such shares have been issued. Concept of allotment of securities. Section 39 of Companies Act 2013, read with Rule 12 of the Companies Prospectus and Allotment of Security Rules 2014, deals with allotment of securities. Allotment. Allotment of any securities of a company offered to the public for subscription shall be made only when the amount stated in the prospectus as the minimum amount has been subscribed and the sums payable on the application for the amount so stated have been paid to and received by the company by check or other instrument. Whenever a company having a share capital makes any allotment of securities, it shall file with the registrar a return of allotment within 30 days thereafter in Form PAS 3 along with the fee as specified in the company's Registration Offices and Fees Rules 2014. Along with Form PAS 3, a certified list of allottees stating their names, address, occupation if any, and number of securities allotted to each of the allottees shall be attached. Further, in the case of securities not being bonus shares allotted as fully or partly paid up for consideration other than cash, a copy of the contract duly stamped pursuant to which the securities have been allotted, together with any contract of sale if relating to a property or an asset or a contract for services or other consideration, shall be attached to the Form PAS 3. When a contract is not reduced to writing, the company shall furnish along with the form PAS-3 complete particulars of the contract stamped with the stamp duty as would have been payable in the if the contract had been reduced to writing, and those particulars shall be deemed to be an instrument within the meaning of the Indian Stamp Act 1899, and the registrar may, as a condition of filing the particulars, require that the stamp duty payable thereon be adjudicated under Section 31 of the Indian Stamp Act 1899. Further, a report of a registered valuer in respect of valuation of the consideration shall also be attached along with the contract of sale if relating to property or an asset or a contract for services, as the case may be. In the case of issue of bonus shares, a copy of the resolution passed in the general meeting authorizing the issue of such shares shall be attached to the form PAS-3. The amount payable on application on every security shall not be less than 5% of the nominal amount of the security or such percentage or amount as may be specified by the SEBI by making regulations in this behalf. Refund of money. In cases where the stated minimum amount has not been subscribed and the sum payable on application is not received within a period of 30 days from the date of issue of the prospectus or such other period as may be specified by the SEBI, the amount received as above shall be returned. The application money shall be repaid within a period of 15 days from the closure of the issue, and if any such money is not so repaid within such period, the directors of the company who are officers in default shall jointly and severally be liable to repay that money with interest at the rate of 15% per annum. Penalty for default. Subsection 5 of Section 39. In case of any default, the company and its officer who is in default shall be liable to a penalty for each default of 1,000 rupees for each day during which such default continues, or 1 lakh rupees whichever is less. Case laws. Judicial pronouncement relating to return of allotment. A. In Sri Gopal Jalan and Company versus Calcutta Stock Exchange Association Limited. The Supreme Court held that the exchange was not liable to file any return of the forfeited shares under Subsection 1 of Section 75 of the Companies Act 1956, that is corresponding to Section 39 of the Companies Act 2013, when the same were reissued. The court observed that when a share is forfeited and reissued, there is no allotment in the sense of appropriation of shares out of the authorized and unappropriated capital, and approved the observations of Harris C.J. in S.M. Nandy's case that on such forfeiture, all that happened was that the right of the particular shareholder disappeared, but the shares considered as a unit of issued capital continued to exist and was kept in suspense until another shareholder was found for it. Allottee Estate versus R.B. Seth Hiralal Kalyanmal Kasliwal. In case of inadequacy of consideration, the shares will be treated as not fully paid and the shareholder will be liable to pay for them in full unless the contract is fraudulent. The third case that is given is Harmony and Montage Tin and Copper Mining Company, Spargo's case. Any payment which is presently enforceable against the company, such as consideration payable for property purchased, will constitute payment in cash. And the last case that is given is Chokkalingam versus Official Liquidator. Allotment of shares against promissory notes shall not be valid. With this, we come to the end of this audiobook. In the next audiobook, we will be listening to General Principles Regarding Allotment. That is from page 47. Thank you.